That kind of togetherness, working together toward a common goal, implies a certain civility, or it should, right? But as adversaries, we don't always have common goals. We are in an adversarial system, and the adversarial is kind of the opposite of the word partner in that sense. It implies being at odds with one another, not having common goals. Bullying disproportionately affects female attorneys, attorneys with disabilities, attorneys of color, younger attorneys, and attorneys with different gender and queer identities. We still have this vexing problem of people being able to leave reviews when they say they're a client and they're not. They're just trying to hurt the lawyer with information that maybe isn't even true.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator today. Now, to kick things off, I want to go ahead and introduce our speaker, James Dopke. James A. Dopke is a partner of the Chicago firm of Robinson, Stewart, Montgomery, and Dopke, LLC. Since 2013, he has concentrated his practice in professional responsibility issues of all kinds, including disciplinary defense and bar admissions, and consultation on legal ethics issues. Prior to that, Jim was senior counsel for the Illinois Attorney Registration and Disciplinary Commission. There, he handled the investigation and prosecution of numerous attorney misconduct matters. He has also participated in presenting many MCLE and PMCLE accredited programs on legal ethics issues, including ABA and ISBA conferences. Prior to working at ARDC, Jim worked as a staff attorney at the Legal Aid Agency in Will County. Jim is a graduate of the Loyola University Chicago School of Law and received his BA from the University of Notre Dame. The webinar presentation that you're about to watch will be approximately 1 hour, and once that is complete, time permitting, Jim will be taking questions from the audience. If you have any questions that come up during the presentation, please feel free to submit them by clicking on the Q&A button in the control panel at the bottom of your screen, and we will address those at the end of the presentation. Now, without further ado, here is Jim to discuss What We Could Be Now, Civility and Ethics 2025.
Thank you, Nina. It's my privilege to be addressing you today as part of this seminar. I'm very happy that you're all here, and thank you for your time and attention today. I am going to be talking about civility and ethics as it is right now. I titled the presentation the way I did, and I got some questions about it, wondering if I was attempting an allusion to the song "Who Can It Be Now" by Men at Work, which was a big hit when I was an early teenager. And the way big hits work, they worm their way into your brain, right? It's an earworm, as they call it. But believe it or not, I wasn't attempting to allude to that. And I mentioned this because, first of all, I did get some questions about it, and second of all, because it's an interesting insight, I think, into kind of how we communicate and the ways that we think different people think different things, right? We know that the problem of other minds, and we never quite know exactly how someone is going to take something that we say, or where someone else might be coming from. And the way this relates to the title is, I was thinking of a song. I am a big music fan and a musical person, but I wasn't thinking of that song. I was thinking of a different one that makes sense to me. It isn't a popular song. It was not a big hit like Men at Work was, although it comes from the same part of the world roughly, because I was thinking of a band from New Zealand who I really have liked since the 90s or so. They're pretty obscure, and like I said, the allusion to them in the title made sense to me, and I like the way the words came together, because it's aspirational. It's thinking about, who are we now as a profession? What can we be now, or who could we be now? And so that's where I was coming from, but other people interpreted it differently. And just that interaction that I had with a few folks made me even think deeper about the kinds of things I'm going to be talking about today, because civility in the profession does relate so much to how we communicate and the ways that we interpret others' actions, the ways we react to other people. And so what we're going to talk about today is, do the rules of professional conduct or ethical principles generally restrain us from acting in certain ways or communicating in certain ways? Um, and how so? How should they restrain us? How will they restrain us in the future? And what does that mean to us as practitioners? Those are the kinds of topics I'll be addressing today. I will not be addressing the more obscure bans from New Zealand, although believe me, I could go on and on about all of that. Um, so, what are our ideas of civility? One idea is a situation in which we, as lawyers, all work together respectfully. That's one way of talking about civility or conceiving of it, right? We use the word partner. We say we partner with one another. That's kind of a modern way of saying you're working together with someone. But we use the word partner all the time because it's a status word for us. It indicates the relationship that we have with others. I have four partners. Um, and but it's also a togetherness word. And that kind of togetherness, working together toward a common goal, implies a certain civility, or it should, right? But as adversaries, we don't always have common goals. We don't. We are in an adversarial system, and the adversarial is kind of the opposite of the word partner in that sense. It implies being at odds with one another, not having common goals. Our clients have different goals from one another, and sometimes we have to think differently than we've thought before in order to represent our clients. Um, our own interests as attorneys differs one to the other, maybe because our clients interests differ and we have to represent them, or maybe there's some other reason why our goals are not shared by a lawyer that we are necessarily working with. um but let's think about what the ABA model rules say in the preamble, section 6, about how it is that we are to work together. It doesn't exactly address the concepts as I was addressing them just now in terms of partnership or adversarialness, if that's a word. What it says is lawyers are public citizens. And as a public citizen, a lawyer should seek improvement of the law, access to the legal system, the administration, access to the administration of justice, and the improvement of the administration of justice, and the improvement of the quality of service rendered by the legal profession. So those are goals that the ABA model rules say we should all be working together toward as public citizens. So that's another concept of the way that we cooperate. We can cooperate as partners day to day. We have to cooperate sometimes as adversaries despite our competing goals and objectives. Um, but we always have to keep in mind that we are to seek improvement together of the law and the legal system. So now the ABA model rules are not law exactly. They don't have the force of law. They form the basis for a lot of the rules of professional conduct enacted in jurisdictions across the country. Not every jurisdiction's rules of professional conduct are the same, and not everyone is the same as the model rules. Each state Supreme Court tailors their rules and their Supreme Court rules and other laws and rules that affect the practice of law. They're all tailored to the particular goals of the legal profession in that jurisdiction. And we're going to talk a little bit today about some recent developments in Illinois, a study that was done in Illinois about the legal profession and certain aspects of it, and a new rule of professional conduct that we have that has been proposed as a model rule, has been proposed in other states, and has not been adopted in certain states and is adopted here. So you see a range of concepts of ethics, but also rules related to civility and ethical concepts of civility. But the ABA model rules are a good place to start, and looking at the preamble is a good place to start. And many jurisdictions have adopted both the model rules and the preamble to them. There is also the concept, of course, of zealous advocacy. And what's that? We often think of the zealous advocate in court acting with zeal, to persuade a judge, to cross-examine a witness, or to argue a case to a jury. We think of those; those are easy to call to mind when we think of a zealous representative. But we have to be zealous in other ways too, in other forums. There have to be zealous advocates in alternative dispute resolution, whether that's an arbitration hearing more akin to litigation, or a mediation that's more akin to a settlement discussion. Zealous advocacy has to take place there too, in negotiations that are not any part of a formal dispute resolution proceeding. Even in consultation with your clients about what to do and how to do it, you have to be their zealous advocate there too. You have to be talking to the client. This is Rule 1.2 for reference, about the goals of the representations and the means by which those goals will be achieved. And that involves, again, a question of what to do, how to do it, but also what are we not backing down from? Or what's a weak part of the case that we have to front and deal with on the front end, or deal with if we get questions later. All of that goes under the heading, to me, of zealous advocacy. It's not just pointing in court and really becoming forceful in court or something like that. All of these fall under the heading of zealous advocacy, and that relates to civility, because when we get zealous, sometimes we can be told that we're not acting civilly. And I have the two images here, one of the courtroom drama, and the other representing what we can do kind of behind the scenes or in an office setting as a zealous advocate. And again, sometimes zeal leads to heightened emotion, because heightened emotion can be persuasive, and yet it can also be perceived as aggressive in a way that sometimes we don't think aligns with our concept of civility. So these are the things that we are all trying to keep in balance, I think. The concept of partnership, the concept of cooperation, even with an adversary, the concept of being a public citizen and advocating for the legal system itself, and the concept of being a zealous and persuasive advocate for your client. All of these are going on and are part of our obligations to ourselves, our profession, our clients, all the time. And that's why civility can be a difficult subject to explore, and a difficult a concept to get a real grasp on that works in the same way from day to day. And that's why it's important, and I felt it was important as I went through and prepared this presentation, to think about where we are now and who we are now, because these things change over time. The concept of civility, the concept of how we can act best to bring all of these concepts together, changes over time. So we want zeal, we know that, but we also want a kind of, I use the word equanimity, a kind of rational balancing, if you will, of the demands of the client against the demands of the profession for cooperation with an adversary, for example. That can be difficult to maintain equanimity and zeal at the same time, particularly, I think, given how instantaneous communication has become. I was licensed to practice law in 1996, and it really was a different world at that time. There are similarities. We did have an internet. My teenage children think I lived in what they call black and white times sometimes, but of course that wasn't true. It was very vivid. But communication was then nowhere near as instantaneous as it is now. Even a phone call, yes, could happen, and it could happen on the spur of the moment, but and you could run into someone and have a conversation with them that you didn't expect to have. But the ways that we can communicate and reach one another now are far, far different and far faster than they ever have been. And that can lead to differences in the tone of those communications, I think. There can be a reaction that you have as a zealous advocate that is passionate and that is unprompted, and therefore very real in a lot of ways, but also something that could be perceived again as more aggressive than maybe it was, even more aggressive than it was meant. And that can give rise to civility problems because the perception leads then to the idea that the lawyer has now crossed a line from being zealous to something that is less permissible or even impermissible. And we reach that, or we believe that of people sometimes, given the fever pitch of just how life is sometimes, or the way world events are that we react to, or the way a client demands something. Sometimes we react to that, and it reflects itself in that reaction is reflected into the ways that we communicate with other lawyers, and that gives rise to one lawyer perhaps accusing another of not being civil. The practice of law sometimes just gives rise to that heightened emotion that can lead to a communication that either is ill-considered and is more aggressive than what you really meant to say, or is perceived that way. I think sometimes back to my days as an ethics prosecutor at the ARDC, and I did that for almost 15 years, and so I have a lot of stories, and I'm not really able to tell that many of them because so much of what we did had to remain confidential in the context of investigations. But some are just stories about people and how they reacted. And I had a conversation once, I always remember, with a lawyer who I called. I needed to call him. In fact, he was a respondent in a case I was prosecuting, and so of course he didn't always particularly want to hear from me. Um, and I think lawyers in this realm kind of have a perception, like in the realm that I was in, have a perception maybe of civility that is a little bit different maybe than other lawyers in other kinds of practices. But anyway, I called him, and he picked up the phone and immediately screamed the word "what?" And I was very taken aback. This was in an era when there was caller ID. So I thought that I would call this person and he would know who it was or be able to understand who it was. And I didn't. I think what worked out was he thought I was someone else that he apparently was not very happy with, because I told him who I was and he changed his tone and we talked in a more civil way. Um, but it's hard to forget when someone answers the phone like that in a professional setting. And I think he just wasn't being careful at that moment, and he legitimately thought that he was talking to someone else. But I think that maybe some things were getting to him, and I think that maybe just the way his life was, and the fact that he was having to deal, frankly, with me at all, might have heightened his reactions. So that's again what I sort of think of when I see this picture, or when I think of the kinds of heightened reactions, the expressive punctuation that you see in this slide was kind of how he was communicating with me. And that, again, we worked through it. I wasn't really offended as much as I was surprised. And of course, none of what he did in that conversation was really wrong, I don't think. But it's stuck in my mind. And the way that we react to others is memorable. And sometimes, again, it provokes these disputes that we have in the profession about what is civil, what is the right thing to do, how should we communicate with one another, given that things are sometimes at a fever pitch. Um, And I wanted to call attention to some cases that have been arising over time, over the last, 4 or 5 years, I would say, because they give an indication of, again, the kinds of ways that communication um, can lead to actual disciplinary trouble. Um, Sometimes when we're having the kind of heightened interactions that I've been describing with others, sometimes we work through them, we get past them. Sometimes we say to one another, "Hey, I think you're crossing a line there. You shouldn't talk to me like that." Other times we just work through it and we don't mention the that sort of meta commentary of, "I don't like how you have spoken to me." And other times, a lawyer is really too wrapped up in something and makes communications of various kinds and makes accusations in those communications that actually are determined to run afoul of the rules of professional conduct. So this is one case, and you see in the lower left-hand corner the citation. It's an Illinois disciplinary case that was litigated back in 2020. Uh, the lawyer was in a dispute within civil litigation over a subpoena that he had issued, and he wound up the other party was disputing whether the subpoena was valid and so forth. The lawyer was communicating with his opposing counsel about that and called them things like insane. You're insane, and you're a maniac, and things like that. Worse, than just insane. But even to say insane, I think was, starting to cross a line, because that's something that is meant as an insult. It's meant to demean the person that you're saying it to, as if they don't have a grasp on reality and you do. But it also is a demeaning reference to mental health issues generally. It's not something that you would expect to see even in a heated dispute. The lawyer also did a sort of trollish tactic of misspelling the opposing counsel's name in insulting ways. Um, he to another attorney, he was shouting on the phone and making threats. He referred to the other lawyer as a target, perhaps a RICO type case or prosecution, as though he was going to bring that. And that raises another kind of issue ethically too, doesn't it? Where you're threatening something that you don't intend to do, or don't really have the means to do, or can't do in a non-frivolous way. That kind of brings that concept into it as well. It's not just name calling, it's taking that extra step beyond zealous advocacy and into making baseless threats that you don't even intend to follow through on. Um, the hearing board, which is the trial level of the proceedings in disciplinary cases in Illinois, really considered the matter very thoroughly. The lawyer did testify in his own defense and did present a defense, which was along the lines of essentially this wasn't that bad. And he claimed too that he had a First Amendment right to say the things that he said. Now, the lawyers, of course, do not forfeit their First Amendment rights when they get their law licenses. That's axiomatic. We do have First Amendment rights. However, in Illinois case law, at least, we have some limits on our First Amendment rights. And the way it's phrased in a case from 1999 that was quoted in this case from 2020 is to say, although attorneys have certain rights under the First Amendment, such protections do not apply to verbal abuse. There are other cases that involve lawyers being extremely critical of judges, to the point of leveling false accusations of bias, and other false accusations generally. And those too have been held in Illinois case law to not be protected, not enjoy the protections of the First Amendment, because they are false, and because lawyers do have an obligation to avoid those kinds of statements, knowing or reasonably knowing, or if you reasonably should know that those statements are false. So the lawyer in the case from 2020 did receive a 3-year suspension and until further order of court, which means that the suspension continues indefinitely even after the 3-year period. That's a very serious kind of sanction. Many different jurisdictions handle that in different ways and with different terminology. This is the terminology we use in Illinois, but many jurisdictions have suspensions, and some will say it's a suspension with no eligibility to be reinstated until a certain time or until a petition for reinstatement is filed, litigated, proved, and granted. And that's what this means in Illinois as well. It's a very, very heavy sanction for several reasons, not just because it continues indefinitely, but also because the lawyer has a burden of showing later that they can and should return to the practice. And it's an important case to think about in that way, or to have this kind of sanction in a civility case is important and instructive because it is intended to signify, and it represents a finding that the lawyer is not presently able to meet professional standards and must later prove clearly and convincingly that they are. So a civility problem can lead to that serious a finding. There's another case that I wanted to highlight from a couple of years before that, and again, an Illinois disciplinary case, in which, again, in the context of civil litigation, a lawyer was defending a deposition that was being taken by their opposing counsel, and the opposing counsel wanted to certify an answer to a question. And the lawyer who was defending the deposition said, "Well, you can certify your own stupidity." So a sort of callous and insulting remark. They had a discussion about that on the record as the deposition was going on, and the opposing counsel who tried to certify the question said, "I don't think your conduct is appropriate here." And the lawyer said, "Well, the standards have changed." Meaning somehow that the state of the world currently and current events currently um, allows in his view allowed lawyers to act in a more coarse and confrontational way. And is that true? I'm not sure if that's true, but that was his contention anyway in the deposition. He also made a very gendered insult to his opposing counsel on the record. He made gendered insults toward women generally. And this was later raised in a proceeding before the judge in the case, outside that deposition, and the judge addressed it, and the lawyer then turned around and claimed, well, the judge was just furious on the bench and was having a robe rage incident in his terminology. The judge later testified, and excuse me, all the parties testified that that wasn't true. The judge had a perfectly even demeanor in handling the issue, and so the lawyer was encountering a disciplinary problem as a result of that, as well as a result of his uncivil remarks. The lawyer did not have any prior discipline, but and that can be a mitigating factor. But there was also no acknowledgement that what he had done was in any way improper, wrong, misconduct, or even just irresponsible. He maintained that there was nothing wrong with anything that he had done. The hearing and review boards recommended that the lawyer be suspended for 3 months. So that's like the trial and the appellate level recommending that. The court can accept those recommendations, or they can do whatever they want based on the facts of the case. And the court in this case didn't accept those recommendations and instead imposed a 6-month suspension on the lawyer. So increasing the quantum of discipline in Illinois. There are technical aspects to that mean that this lawyer had to shut down his law office and not petition for reinstatement later. It's not like that. But a 6-month suspension, it imposes more requirements on a lawyer in Illinois. That may be true in your jurisdiction as well. And in any event, it was just a heightening of the level of sanction by the court. And so that's an interesting thing to think of too. Did this rise to the level of that indefinite suspension? No, it didn't, according to both the hearing and review boards and the court itself. But it was serious enough to require that the lawyer be suspended for that operative and meaningful length of time. And the court thought, well, 3 months is a 3 month suspension is, something. It's not nothing. It's not a slap on the wrist, but the court thought more is needed here. And that's an interesting thing to observe, because and we don't, when the court does that, it doesn't necessarily articulate its reasoning, but it's telling you something by telling you what the result of that case is. And what it's telling you is that it takes civility seriously. At least that's how we interpret it here. I want to move out from Illinois a little bit and go into a California Civility Task Force report that was created recently. And what it recommended was interesting. It recommended additional civility training for through an MCLE, to encourage lawyers to really study and learn about the connection between bias and incivility, and urging lawyers to eliminate bias-driven incivility. So that's one document. I think maybe somebody is off mute. If you could mute yourself, that would be helpful for the other attendees. Thank you. This Civility Task Force also recommended optional training for judges, modeling civility and curtailing attorney incivility. So recognizing that judges play a role here too, and recognizing that judges' demeanor can sometimes influence whether lawyers are behaving more or less civilly. The California report also recommended changes to California's disciplinary rules, which actually have been changed fairly recently to resemble the model rules more than they used to. But the changes recommended are those that would prohibit repeated incivility, and those that would clarify that civility is not inconsistent with zealous representation. So again, seeking that kind of balance. Is a rule really necessary for this? That's a legitimate question we can all ask, I think. But this was the recommendation of this task force. And very interestingly to me, the task force recommended that lawyers be required to affirm or reaffirm every year that as an officer of the court, they will strive to conduct themselves at all times with dignity, courtesy, and integrity. So a sort of symbolic approach there for that last recommendation, a way for each practitioner to articulate to themselves out loud that they're going to behave in a certain way with dignity, courtesy, and integrity. And again, those are concepts of civility that I think align with the ABA public citizen idea, that align with trying to balance zeal and aggressiveness, trying to balance zeal and equanimity, trying to have all of those things contained in one professional approach. We will see how far the task force recommendations go. I don't know that rules will be enacted as a result. That's typically what we see in the ethics realm, is that it's asking for a rule on civility to be adopted is a heavy ask. And it's something that the profession has a lot of viewpoints about. And that's part of why we're having this discussion today. And if you have questions as we go along here, by the way, please feel free to weigh in. But and we have a question and answer period at the end as well. But asking for a rule, a real rule of professional conduct that has disciplinary implications about civility, is something that a lot of jurisdictions have difficulty enacting for one reason or another. And I'm going to get to what Illinois' approach has been with that in a minute, not because I want to be Illinois centric, but just to show that there are approaches that do sometimes take hold. We did have a report here that I wanted to mention that was a statewide study of more than 6,000 lawyers on the topic of bullying. And this is, again, something that relates to civility, because incivility is one thing, a stray uncivil remark is one thing. Even the kind of approach in one case that we saw in the two disciplinary cases we looked at, that's one thing. But bullying is another. Bullying seems to me to be a kind of systematic incivility that involves a power dynamic, right, between one lawyer and another, a senior and a junior lawyer, for example, or two lawyers, one of whom thinks that they are they are in a position of power, even though they're really not. Two partners who have a dispute where one and one begins to bully the other. Sometimes there's a perception that a judicial officer can be a bullying figure to an attorney, and so attorneys were asked about their thoughts about bullying in the profession as part of this study. It was found that bullying disproportionately affects female attorneys, attorneys with disabilities, attorneys of color, younger attorneys, and attorneys with different gender and queer identities. It was found that there are negative professional, emotional, and physical effects from bullying, and that almost 20% of the respondents to this survey reported leaving legal jobs due to bullying of one kind or another. And that is something to reflect on. You know, it's data that's accrued from some lawyers, and we remember we do have more than close to 100,000 licensed Illinois lawyers. Oops, I'm sorry. This is a relatively small slice of our legal profession here in Illinois, and the Illinois legal profession is not necessarily representative of every place in the country, but it's data, and it's data that shows how people are living with not just uncivil conduct, but as I say, I think systematic uncivil conduct, conduct that exploits or tries to exploit a power dynamic, and the effects that that can have. We do have Rule 8.4J in Illinois now, and this is something, again, that you may have heard about in other jurisdictions as having been proposed. It was proposed in Pennsylvania, but was declined to be adopted as a First Amendment infringement. And yet it's been adopted here in Illinois. And so it's been proposed in other jurisdictions. It's an actual rule here. It has not been enacted for very long. And so we don't know exactly how it's going to be enforced yet by ARDC. Or it's too early to tell, I guess is what I would say. What Rule 8.4J says is that it's professional misconduct for a lawyer to engage in conduct in the practice of law that they know or reasonably should know is harassment or discrimination on the basis of race, color, ancestry, sex, and all the other identities that you see here. It does not limit the ability of a lawyer to accept or decline or withdraw from a representation. And it doesn't preclude giving advice, assistance, or advocacy consistent with the rules, but it prohibits actions that amount to harassment or discrimination of these kinds. Previously, our Rule 8.4, and this may be still the rule in many of your jurisdictions, previously our rule said it's unlawful to engage in this kind of discrimination, but no action can take place based on that unless and until there's been a finding by a court or an agency to the effect that the lawyer has engaged in that kind of discrimination. So, for example, an EEOC determination or a Department of Human Rights determination or something like that, that was required to have been found in order for there to have been a violation of the rule. And that didn't happen all that often, at least in my experience working as a disciplinary prosecutor, or really as a defense lawyer on the other side either. Now, this rule is not dependent on that kind of other administrative or litigated finding. The Attorney Registration and Disciplinary Commission itself can investigate and address whether a lawyer has engaged in this kind of harassment or discrimination. I don't know that I would say that so far I have seen a lot of or a giant increase in reports to the ARDC or to our disciplinary agency about this kind of conduct. And again, it's too early, excuse me, for me to tell exactly how the agency is going to handle it. But it is a rule. And it is something that it is now codifying um, as against the rules, a kind of uncivil behavior, a kind of behavior that we have historically put in the category of civility as a concern, as a potential problem. Now it's also a potential ground for discipline. And maybe this rule will be adopted in other ways in other jurisdictions. Maybe it won't. It is difficult to tell. Again, when it's proposed, it tends to receive a lot of commentary and pushback from some areas of the profession who feel, for example, that it infringes on First Amendment rights, or that simply a rule is not appropriate because the opponents of this kind of rule sometimes question, what is harassment? What is discrimination? How is it that a disciplinary agency will make the determination of what those things are and whether they have occurred? Um, and I think while this kind of rule certainly is something that we should all aspire to avoid that kind of harassment or discrimination. Again, I don't know the answer to the question of how a disciplinary agency is going to define those terms or what that might mean for us going forward. But Illinois is kind of putting itself in the vanguard of determining that, and we will see as it goes along how the court enforces it, what kind of sanctions we can expect a lawyer to receive for conduct of that kind. It's just no prosecutions have been undertaken. We do know that lawyers can be disciplined, for example, for gendered name calling, for insulting the integrity of another professional or a judge baselessly. We know that, and we've seen that it can result in suspensions of 6 months or quite a bit more. But we don't know exactly what kinds of sanctions will result from violations of Rule 8.4J itself. I want to address, we did get one question as I was going along here before we move along to a slightly different topic. What if an attorney is concerned that another attorney is not acting ethically or does not understand a legal issue and is misstating the law? How does the attorney express these concerns to the other attorney without experiencing retaliation or simply being ignored? I think that's a very good question. I'm going to answer it live and click on the fact that I'm doing that. And I think the answer is that I think it's well within your bounds as a zealous advocate to say that, to say to another lawyer, our argument is not well supported, or your argument is baseless, or your argument is frivolous. We do have that concept, of course, in the rules of professional conduct, the rule that prohibits us from making our arguments that have no basis in fact or law. And of course, there are rules before tribunals that restrict the lawyer's ability to make a frivolous argument and can result in the imposition of sanctions. And I think it's also true that a lawyer can say, not only do I think that your argument is frivolous, I'm prepared to litigate that and seek sanctions if you proceed. I don't think there's anything uncivil about making the other attorney aware of that. And if there is pushback, then I think there is. I think this is, again, something that lawyers encounter in litigation and dispute resolution quite frequently. And I think it can and usually does stop well short of being anything that I think would result in a discipline for uncivil actions. That said, sometimes those disputes do lead to reports, for example, by one lawyer of the other to the disciplinary commission. And can you do that? Is that okay? Well, yes, and in some jurisdictions, in many jurisdictions, including my own, It may be mandatory to report another lawyer to the disciplinary commission, not necessarily for uncivil actions. In our jurisdiction, it's for a dishonesty or criminal conduct that a report is mandatory. Check your local listings, though, because that's not the same rule in every jurisdiction. But it may be, if the dispute becomes something that does involve a lawyer's honesty, or even potentially threats that rise to the level of criminal conduct, then the lawyer who is receiving those threats or has knowledge of them may need to report that to the disciplinary commission, which is an escalation. And I think that's kind of where that question was going. What if these disputes escalate, and how can we ensure that they're not going to escalate to a point where it becomes a problem? And there's no great answer to that. I think you can. Again, I encourage lawyers to be upfront with one another about those kinds of arguments. I don't think you have to refrain from telling another lawyer, I don't think your argument holds any water. I don't think a civility ideal prevents you from saying that. Um, but what if it escalates to the point of the other lawyer then reporting you to the disciplinary commission? Well, as a disciplinary defense lawyer, I often say, well, that's not something anybody wants, of course, and but at the same time, that's a manageable situation. That's something where the lawyer who is reported can respond in a measured way to the disciplinary authority, and tell the disciplinary authority, here's how this came up. And here is how we dealt with it. Here's how the other lawyer acted, and I respectfully submit that my conduct didn't violate a civility principle. And this is done in our jurisdiction, in my jurisdiction. This is done on a confidential basis, and is not something that is, if it's dealt with in that way, is not something that's likely to lead to the kind of horror story prosecutions in disciplinary matters that we've seen before. So I hope that answers the question. We do have another question here. It's whether in criminal matters lawyers are permitted to act simultaneously as a probation officer. I think we'll go on from there and maybe address that as we go. So I wanted to pivot a little bit to a sort of related concept under the heading of civility. Civility in responding to negative reviews. This is something that comes up rather a lot. It was not something that was an issue when I started giving CLE presentations about a third of the way into my career as a disciplinary prosecutor in about 2005 or so. It just didn't come up as much as it does today. Why? Because online reviews were not really as big a thing as they are now. And we didn't have a Google mechanism by which reviews could be appended to a profile and could follow you around and had the power that they have now. And it's because of that power that lawyers have to be careful, even as they are understandably concerned and reactive to reviews. And it's something that does have ethical boundaries. These are not just shoulds. There are some musts and shalls that you have to pay attention to as you think about this issue. Model Rule 1.6b. Again, this is from the ABA rules, and it forms the basis for a rule of professional conduct that's enacted in many different jurisdictions. The general rule is you keep information relating to a representation confidential. You must. That's one of those musts. Except in order to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client, or to establish a defense to a criminal charge or civil claim against the lawyer based on conduct in which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation of the client. Again, check your local listings. Not every jurisdiction is going to phrase this exception in the same exact way. But there is this principle that is built into the model rules and therefore kind of foundational to our understanding of client confidentiality, that allows for the disclosing of some information for the lawyer to push back, in a sense, on an accusation of wrongful conduct. And comment 10 to the model rule gives us some more description of what that really is, where a legal claim or disciplinary charge alleges complicity or other misconduct. The lawyer may respond to the extent the lawyer reasonably believes necessary to establish a defense. So here I want to highlight the extent language, because this is meant to be a narrow exception, like a lot of exceptions to the confidentiality rule. It's not meant to mean that it's not meant to say that a lawyer can simply start putting stuff on the internet in response to a mean thing that a client said. The lawyer has to have a reasonable, i.e., objectively reasonable belief that it's necessary to respond in a certain way using some limited amount of information relating to the representation. The same involving the civil or criminal or disciplinary proceeding that's alluded to in the rule. The right to respond arises when an assertion of complicity has been made. So this is addressing a situation where someone is saying, well, this client did something bad, and it's the lawyer's in it with them. The lawyer is doing it with them or has done it with them. And is it necessary? Is it reasonably necessary for the lawyer to respond and say, hey, no, that's not what happened? Maybe. And if so, the lawyer has some leeway to respond. And the lawyer doesn't have to wait for the commencement of an action or proceeding, according to comment 10 to the model rule. Again, look at your rule in your jurisdiction, because this language may or may not be present. The defense may be established by responding directly to a third party who's made such an assertion, even if we're not talking about a malpractice case, a disciplinary report, or something like that. This is, again, getting somewhat controversial here and getting a little bit into a hard to define area. What does it mean to respond to something without a proceeding? And are we talking about online reviews? Can the lawyer do that? Can the lawyer start just responding to a Yelp review or some other, Google review or something like that with information relating to a representation? Well, it says there's no proceeding necessary, so I should just go and do that. Again, as a lawyer who counsels people on these kinds of things, I say act with caution, even though that's sort of what the comment says. Look at your own local rule that actually governs your conduct and still be careful. The restatement to the law governing lawyers, which is again a sort of theory text about what the ethical principles are. Lawyer can respond when and to the extent reasonably necessary to defend herself against a charge that she acted wrongfully in the course of representing a client. So again, a slightly different gloss on this. A charge. What's a charge? Does that mean like a written charge, like a charge in a malpractice case or a disciplinary charge? Or is it just, I charge you with having done something wrong, like in a review or something like that? And what's a charge? What's a controversy between a lawyer and a client? Is a bad review enough to say, well, they're causing a controversy about my services, my reputation. They're hurting my reputation by means of something that I want to demonstrate is false. Mere criticism of the lawyer may not be sufficient to warrant disclosures in self-defense. This is a New York case. Even when criticisms appear in the press. So that's one view. Mere press reports aren't enough to allow you to use confidential information to respond to a client or to an accusation of improper conduct. But and there's a New York ethics opinion that endorses that as well. But there's an Arizona ethics opinion from 1993, that long time ago, but it does interpret controversy to include disagreement in public media. Were they thinking about Google reviews? Certainly not back then. But they were thinking about accusations in a public forum of some kind. And can the lawyer respond to that the way this ethics opinion said? Yes, but not super broadly. Our conclusion should not imply that an attorney may simply open his or her file to respond to derogatory allegations. Again, we have the concept of what's reasonably necessary and the attorney's independent judgment and careful assessment of the situation. So where does that leave us? not anywhere clear, right? And yet we still have this vexing problem of people being able to leave reviews when they say they're a client and they're not. They're just trying to hurt the lawyer with information that maybe not isn't even true, maybe outlandishly untrue, and the lawyer is still restricted in some way from being able to respond to that. So what are some guidelines that we can think about here? We can think again, as I've said, about proceeding with caution on this and proceeding with the idea of civility in mind. This is wrapping in not just what should we do or what must we say that's not confidential, but how must we say it? And will a response that's kind of coming in hot, will that reflect on us poorly from a civility standpoint? Maybe. And it will look in a minute at a couple of cases that address that, a couple of disciplinary cases, unfortunately, where I think some intemperate language might have helped to give rise to disciplinary trouble. But your options in general for responding to a negative review are let it be, i.e., don't respond. Deal with the website that it's on. If you can really say, look, this person says they're a client, they're really not. There are some sites that will say, well, we only accept comments from clients. And if you can demonstrate, lawyer, that this is not a client, we will take it down. So think about that. There are reputation repair companies that advertise the ability to remove negative information from the internet. That is often an expensive proposition and maybe not effective. So think about that. But it's not out of it wouldn't be ethically impermissible necessarily to engage such a company. You can respond with a sort of anodyne statement and say, well, ethical rules constrain me from being able to respond, but I always strive to provide all my clients with excellent service and communication, or something like that. That's a typical kind of response that you can see that elevates the discussion, right? And that indicates that you have a dispute with what this person said, but you're not really allowed to go into it. You can also create a different and more positive internet presence. You can ask other clients who are satisfied with your services to review you and provide a positive review. Maybe if it rises to the level of defamation, you can seek advice about whether there are civil remedies that you could explore. I saw one reaction once, or a lawyer that I follow wrote about a reaction that he had to a poor review, which I wanted to highlight. He did say, well, I can't respond substantively to this bad review. There are ethical concerns that prohibit me from doing that. I can say that I don't agree with this assessment, and I always strive to provide better service. And then he used that response to put up a poll underneath that comment. He put up a poll that said, now, if you're a prospective client and you just read that response, what did you think of that? Does that make you more or less likely to hire me? Or are you more affected by the negative review that you see above? Did you like my response to the negative review? Did you find it trustworthy? Why or why not? Would positive reviews help, or how do you react to positive reviews? So this lawyer really took an approach that tried to maximize the utility, in a way, of the negative review. And, because he wanted to use it as data to see what works and what doesn't work, and how does this stuff really affect his practice and his ability to get and retain clients. I thought that was very interesting. And it, again, elevates the civility of the interaction. To respond directly to the complaining client, or perhaps non-client, or false individual, or whoever it is, to respond directly can lead to a civility problem of the kind that we were talking about at the beginning of the presentation. The emotion is heightened. I know how this feels. I know it myself, and I know how it feels for my clients when they are accused of things. I represent a lot of people who are accused of things, right? And it's hard when you're a professional to be accused of something that you feel you did not do. And when you feel that you really laid out for a client and you did your best for a client, and they are turning around and impugning your integrity, that is difficult to deal with. And the emotions can rise and get heightened, and that can lead to risks. This lawyer did a sort of analytical approach There are other approaches, as we talked about on the last slide. I think doing the analytical approach helps to ratchet it down and maybe help you focus on something else other than the fact that this is an obnoxious an untrue allegation. You can turn it into a positive by turning it into making yourself appear to be the inquisitive and thoughtful professional that you are. Or you can just roll the dice and see what happens. You can try to respond in a way that you think defends your honor, your professionalism, without using confidential information. Remember, there's always that. When I say roll the dice, I don't mean go nuts. I mean, respond in a way that does not reveal confidential information or any information relating to the representation. You can try to rely on that exception that allows for some give on that, but that's a risk. Know that that's a risk. But if you wanted to respond around that or through that in a way that you think responds appropriately to an allegation, I can't tell you it's unethical to do so. What I can tell you is that there have been cases where lawyers have been disciplined for their responses to negative reviews. This one was from Oregon. The client included some information in a review while calling the lawyer horrible and very crooked. The lawyer responded with information relating to the client's case and criminal charges that the client had been the subject of. Also used the client's full name, but later edited that and deleted. The Oregon Supreme Court said, look, there is a ban on revealing confidential information, and that includes matters that are even in the public record. So, and that's true. That's a standard interpretation of Rule 1.6. Even if it's already public information, it may not be the lawyer's to reveal. It determined that the 1.6 exception for revealing information in a client controversy was not applicable because the information that the lawyer revealed was not necessary to defend the lawyer. There was substantial mitigation. The lawyer had never been disciplined before and was cooperative, and so was reprimanded, which it was a public reprimand, so that's why we know about the case, not a private reprimand. And not every jurisdiction has private reprimands, but in any event, it was public discipline, but it's not discipline that affects the lawyer's right to keep practicing. There was a similar case in Illinois in 2013 in which a lawyer did basically almost the same thing. The client left a bad review on Avo, accusing the lawyer of taking the fee, knowing that the client would lose and wanting more money and being money hungry and all of that. And the lawyer said, hey, would you remove that review? And the client said, yeah, I'll do it after you return my file and give me a bunch of money. Avo did remove the review anyway, but the client reposted it, at which point apparently the lawyer got frustrated and responded with more information than was necessary, including alleged misconduct by the client. The lawyer was found to have violated Rule 1.6 and Rule 4.4, which prohibits a lawyer from using means that have no substantial purpose other than to harass or embarrass or burden another. So that's part of why it's not a good idea to include client-related information or say something like, well, this person doesn't know what they're talking about. They're a crook, because that could be seen as only harassing and nothing else. And this lawyer, too, was reprimanded. So again, public discipline, but not that which would affect the lawyer's right to practice. I hope this has all given you some food for thought. I hope that the stories of disciplinary of disciplinary cases are not too scary. I don't mean them to be. I mean them to be illustrative. Uh, I think, and you know what? Here's a case in point. We got a comment that's not exactly a question, but a comment. Was there a better way that I could have thought of to say when I said the term "go nuts" a few minutes ago? Should I have said something else? I think that's actually a good point, and I will keep that in mind going forward. I could have used a different term. I could have said "go beyond the norm," as this commenter suggested, and I will do so. And I apologize for that. Another question that we have here at the end is, can you talk about the outcome of a lawsuit? what can or can't you say when you win or lose? And this, I think, is addressing the idea of um, can you report to others that a certain outcome was achieved in a lawsuit? Is that public information? And it may be. I mean, it's something that someone could walk into a courthouse and find, the order terminating the case, either with a huge verdict or a not guilty or whatever it is. Somebody could walk right in and find that information. Must a lawyer still keep that information confidential, even though it is public? Broadly speaking, generally speaking, yes. Um, I would say so. Um, I think that that is something that can be discussed with a client, because client consent is always an operative exception to the confidentiality rule. If you can, if the client allows you to use that information for their purposes, then you can use that information. Or if the client allows you to use it for your purposes, like on your firm's website, achieved a $7 million verdict in this case, can you do that? Get the client's consent. That's the best practice, because your jurisdiction may not, like my jurisdiction, may not otherwise allow it. And it's best to discuss that kind of thing with the client anyway. So that's my answer to that. A few other questions. Are younger generations of attorneys experiencing civility differently than older ones? Um, I wonder about that. I don't know exactly if I have all the knowledge in the world to answer that. I think can mentorship adapt to bridge that divide? That's a wonderful question. Or how should mentorship adapt? I think as a lawyer who is now in my 30th year of practice, I think about mentorship, and I observe young lawyers when I represent people in admissions matters. I see people very much. Some are young, some are already have some work experience under their belt, but all are new to the profession, and I think they are experiencing civility in different ways. Again, I think with that instantaneousness of communication, with the way the internet is, with the media sources that they have that didn't exist before, and the way people communicate on those media sources. I'm not sure that they have the same ideas about how lawyers communicate than were prevalent when I entered the practice 30 odd years ago, 30 years ago. And I'm not sure exactly how mentorship should change to reflect that. I think if mentors, maybe if mentors could make a resolution, if you will, to be aware of the different kinds of ways that younger lawyers communicate, and talk to them in detail, and participate in mentorship programs, and ask them about the communications they receive from one another, from older lawyers. Review that bullying study, because some of the bullying aspect of communications results from a power dynamic that results from different generations dealing with one another. And I would be interested to know what are younger lawyers' perceptions of that, and how are they experiencing civility in that context. So it's a great question. I wish I had a definitive answer to it. Um, Quickly, one last. With generative AI becoming more prevalent, how do evolving technologies complicate or reinforce our existing ethical duties of competence and candor? That's another really great question. I think certainly we see issues involving candor to tribunals in the headlines, right? When it comes to AI, when there are cases that arise where lawyers have submitted AI generated content to a court. Sometimes what the court faults them for, when that content turns out to have been hallucinated, is candor, because and sometimes courts' approaches to dealing with this situation involve additional representations to the court that the court expects to be candid. That is a representation, a sign off that says, the lawyer, certify that either I did not use generative AI, or I did and I checked its work, or something to that effect. Some courts are beginning to require that. As an additional level of competence, candor, and really civility, because the lawyer is expected to be candid, not just to the tribunal, but to the other counsel on the case, and in a way to submit something to them and force them to do other work, force them to deal with the situation that was created by the wrongful content, if you will, is in itself perhaps lacking in civility in a certain way. It's burdening another attorney with additional work that shouldn't have to exist, and with professional obligations now that shouldn't have to exist, and that could be seen as detracting from the lawyer's own ethical obligations to civility. So I think AI is affecting this kind of stuff. I think using AI generated content again is something that can be done. I can't say it can't be done ethically. I think it can be, but it has to be done utterly carefully, or else the lawyer could be exposed to accusations of incompetence, of a lack of candor, and a lack of civility too. So I hope that's been a good discussion. Thank you for all the very thoughtful questions. I really appreciate that. I appreciate your time and your attention today. I hope it's been helpful to think about. And thank you again to Justia for its hosting of this presentation. Thank you all.
Thank you so much, Jim, for that wonderful presentation and answering all of our audience questions. And thank you all for sending in your thoughtful questions. We really appreciate it. We want to thank you all so much for joining us for another Justia webinar. As I mentioned today, before you go, don't forget that Justia Connect Pro gives you access to CLE credit opportunities through select live and on-demand webinars just like this one to help you stay informed and keep you compliant with your requirements. Plus, you get other perks like an enhanced directory profile with a pro badge, no competitor ads, access to our Justia AI-powered chat that helps you connect with more leads, as well as a $200 credit to put towards Justia marketing solutions, and more. If you're interested or you'd like to learn more, you can go to pro.justia.com. Thank you all so much for joining, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.